because it is in our story where we truly find that in our DNA, that same DNA that flowed through our ancestors is here today. And that trail of tears, that forced removal, is where we find that resilience so many times.
And so as you think about your journey, about where you have been personally, not only your ancestors, not only your great-grandparents, but where you have been. And we are in the midst of a revitalization right now that is so exciting. The Trail of Tears has some very meaningful stories, but each one of you has stories.
We must amplify our historical perspective and not allow a modern removal. Sovereignty and self-determination are too valuable for future generations. However, this will require not only the strength of our tribal leaders, it will require the strength of our people.
And we know the battles and we know the scars that our ancestors felt because we feel those. And when we peel these layers back, we can find that healing. And our country, our tribes are undergoing a time of healing continuously. But today, we understand that there's so much that is out there for each of us to grasp and to take hold. And it is organizations like this that are going to be paramount to what our youth see tomorrow, so that they can have a future and pass these stories and these things along in the most relevant and the most righteous way each and every day.
We wouldn't be gathering here knowing that we've got a great Cherokee democracy. We wouldn't be here, and I couldn't be here as a chief of a nation, because our nation might not exist. But it does exist. The Cherokee people are still here. We're stronger than ever, and part of our strength is we've got great friends in the National Trail of Tears Association. Thank you all very much for your friendship and your work.
So this is the law portion. I know you're thrilled of the morning, but it's actually more than that, and I am beyond excited right now. I get to make a public announcement. I've been getting texts this morning from various, sorry, I really am gonna have to just stare. Or I could hold it, oh better. This is the game show method. Okay, so we have beautiful prizes. No, I won't do that. So I've been getting a text this morning in the last 15, 20 minutes. This just got dropped on the national news, and I told folks I was going to share it with you, and they were thrilled that I would. Here's the headline. Biden nominates first Native American woman to Oklahoma federal judiciary. And even better, it's my friend. I'm a friend of many of those in the room. I'm guessing Sarah Hill, former Cherokee Nation Attorney General, who just stepped down and evidently decided this is what she wants to do next. I'm going to read the first paragraph. This wasn't in my pre-prepared thoughts on what I would say, but what a joy it is to be able to do this. Today, President Joseph R. Biden announced his intent to nominate Sarah Hill, Cherokee, to serve as a federal judge in the United States District Court for the Northern District of Oklahoma. Ms. Hill is President Biden's fourth Native American judicial nominee, and if confirmed by the U.S. Senate, which is expected, would be the first American Indian or Alaska Native woman to serve as a federal judge in Oklahoma. Imagine that. She would be the only actively serving Native American federal judge in Oklahoma, and the seventh actively serving as a federal district judge in the United States. She's not here, but can I invite a round of applause for Sarah? That's absolutely wonderful news. So what am I going to talk about? It's hard to talk anything beyond that. It's huge news. It's significant historically, and maybe I can use it as a segue to what I think is an undertold story in the Trail of Tears narrative, probably not among you, but nationally, which is the role that the Supreme Court played, both good and bad, in the Trail of Tears forced migrations of the southeastern tribes. The good part, most folks know, you've heard of Worcester versus Georgia, and I'll talk about that. One part of the story that isn't told, though, is the darker part. I believe, accidental part, which is the Johnson versus McIntosh story. And as Jack mentioned, I wrote a book about this that took 14 years because it took forever to find any of the primary materials. That story was so unexpected it could be a different talk, but I found them in the possession, the basement of a furniture maker outside of Philadelphia. The entire corporate records of the plaintiff, Illinois and Wabash Land Companies, in Johnson versus McIntosh, hundreds of documents related to that case that turned out to be collusive, that gave us something called the discovery doctrine, about which some of you may know. That was the case that basically resulted in the dispossession of title to all the lands of North America discovered by Europeans, including the lands of the Cherokee Nation in Georgia and North Carolina and Virginia and elsewhere. Lost to the discovering English and then to the United States, and a loss that played a significant role, as I'll discuss, in the sort of pressing of the removal process by the Jackson and Van Buren administrations. So that case I want to begin with, and then I'll tell you, I'm actually going to read a part of it just because I think it's important to hear. I'll give you a little bit of the background if you decide, gee, this is really cool, and you want to know more. Jack referenced, Jack and I and Chief Hoskin, who is a treasured former student of mine from the law school at Oklahoma, and others were invited to deliver speeches at a panel held at the Virginia Museum of History and Biography the week before COVID caused a national shutdown. C-SPAN covered it, and so you can watch me and Jack and Chuck and others on C-SPAN. The title of the conference was, I think, John Marshall, the Supreme Court and the Trail of Tears. And it's gripping, right, Jack? Yes, it's gripping. So if you've got nothing to do one Saturday and you want to invite all your family over to hear this story in much greater detail, and I'm going to focus on sort of a part of it that I've been thinking a lot about lately. So, all right, that's a lot of introduction. Johnson versus McIntosh, case number one, and this is John Marshall. We're going to spend some time with him right now. Johnson versus McIntosh arose from a late colonial land speculation in the 1770s, 1773, and 1775. The British Empire in North America was starting to break apart. You'll remember the Boston Tea Party and this sort of thing. And land speculators, being land speculators in Philadelphia and Baltimore, decided to take advantage of the confusion, the political confusion. Sent wagon loads of trade goods out to what would become the states of Indiana and Illinois, and in two separate transactions in 1773 and 1775, purchased by treaty a pile of land from the Illinois tribes and the Piankashaws and the Weas and others, the Peorias. Land, as one of them would later say, more land than all of England, and it's true. When you look at the maps, it was an absolutely enormous quantity of land. Then they spent 50 years trying to get somebody to recognize their title to this land. The British wouldn't, the Virginia colonial government wouldn't, the Virginia Revolutionary Convention wouldn't after the war started, the Continental Congress wouldn't, then they went to the U.S. Nobody said no, mind, with one exception, but nobody said yes, and they pressed this thing, paying off members of Congress, some of whom you've heard of, and I won't spoil the story. You can watch me and Jack or read the book. And finally decided the only way we can get somebody to recognize this is through the Supreme Court. They filed a lawsuit in 1818 or so. The case went to the Supreme Court, was finally heard by the Supreme Court in 1823 as the Johnston-McIntosh case, and they lost, which is why you've never heard of them. Had they won, my friend in Pennsylvania, who had the documents, would be a name that you would know because he would own most of the Midwestern United States, or others in his family and other descendants of the groups of speculators. And the world would be a very different, a very different place. So How did the court decide? Well, the principal grounds I won't go into, the material grounds had to do with whether a British royal proclamation prohibiting individual purchases of land from the Indians, the proclamation of 1763, was constitutional or not, was valid or not, and the court decided it was, and so there you go. But that is not what most people read in the Johnson versus McIntosh opinion. The first 15 to 20 pages of an opinion that's not much longer than that is devoted to the exposition of this thing called the discovery doctrine. I want to read you the language in the opinion where Marshall announces that this doctrine is the law in the United States. Then I want to explain what subsequent scholars and courts have interpreted him to mean by that. And then I want to talk about how this is really what gave us Indian removal. Here's the language. Marshall says, on the discovery of this immense continent, the great nations of Europe were eager to appropriate to themselves so much of it as they could respectively acquire. Its vast extent offered ample field to the ambition and enterprise of all, et cetera, et cetera, et cetera. Skipping ahead, but as they, the European powers, this is France, Spain, et cetera, were all in pursuit of nearly the same object, it was necessary, in order to avoid conflicting settlements and consequent war with each other, to establish a principle which all should acknowledge as the law by which the right of acquisition, which they all asserted, should be regulated as between themselves. This principle was that discovery gave title to the government by whose subjects or by whose authority it was made against all other European governments, which title might be consummated by possession. Now, the key word in that is this word title, because we're not exactly sure what he means by that. We know that this is a rule he's decided that was designed to avoid warfare among Europeans. So I'm going to skip ahead to a fuller explanation, what he thought the real property consequences of discovery were. If you want to think of it this way, what the legal consequence of that guy in the puffy shirt planting a flag and saying, I claim this land in the name of, what that actually meant as a matter of law. Here's what Marshall says. In the establishment of these relations, the rights of the original inhabitants were in no instance entirely disregarded, but were necessarily to a considerable extent impaired. They were admitted to be the rightful occupants, that's the key word, of the soil, with a legal as well as just claim to retain possession of it, that's another key legal term, and to use it according to their own discretion. But their rights to complete sovereignty as independent nations were necessarily diminished, and their power to dispose of the soil at their own will to whomsoever they pleased was denied by the original fundamental principle that discovery gave exclusive title to those who made it. Here's how this is understood today. So this is what we call the discovery doctrine, as it appears in Johnson versus McIntosh, as it's adopted by the United States Supreme Court in 1823, and it has two components. The first is that upon discovery, the indigenous peoples of the discovered lands lost the underlying title to their lands to the discovering European sovereign. By sort of some magic operation of law, the ownership of the land, the title to the land, vested in the discovering European sovereign. What remained to the tribes was an occupancy right, a right to use the land, to possess the land, but they didn't actually own it, understand, and that occupancy right was transferable, alienable is the word that we use, they could sell it or give it, but only to the same discovering sovereign. So there's a market of one if they should decide to sell it. Those are the two components, the vesting of fee title in the discovering sovereign and the what I call the restraint on alienation, that you can only alienate it to the discovering European sovereign. Now, that's huge, and I'll explain why later. That is the law today. Not only in the United States, but in Canada, Aotearoa, New Zealand, Australia, Guyana, and elsewhere in the former English colonial world. Two questions I'm going to ask and answer fairly briefly. just because I find them both stunning. And this is what took me 14 years to pull together. The first question Marshall answers in the next paragraph of the opinion, which is, why is this there? What, given that the whole of the opinion could have been decided with just that reference to the Royal Proclamation of 1763 that I alluded to a minute ago, why is all this discovery doctrine stuff in there? And he tells us in the next sentence or two, which is, while the different nations of Europe respected the rights of the natives as occupants, they asserted the ultimate dominion, the ultimate title, to be in themselves, and claimed and exercised as a consequence of this ultimate dominion a power to grant the soil while yet in possession of the natives. These grants have been understood by all to convey a title to the grantees, subject only to the Indian right of occupancy. That ended up answering the question of why he put it in here. This is a much longer story I won't go into, but there was a contemporaneous dispute going on between the states of Virginia and Kentucky over who had the power, Virginia or Kentucky, to grant title to former Chickasaw lands in southwestern Kentucky that Virginia had promised to its Revolutionary War veterans. And by creating this discovery doctrine that provided that ownership went to the crown and then to the state, that dispute was resolved in favor of Virginia, and Marshall had reasons for doing that. So this is, I think, the full explanation for the why. The second question was, well, where did this come from? And the deeper I got into this book, the more suspicious this whole thing appeared to be, because I couldn't find any reference anywhere else to this being the consequence of European discovery, ownership of land from anything prior to this, including English law prior to this decision. And so you jump back into the opinion, and Marshall will tell you where it comes from. He says, the history of America from its discovery to the present day proves, we think, the universal recognition of these principles. And then there's a lengthy discussion of the terms of English colonial charters and allegations that they absolutely prove that the Crown understood this to be the rule. They don't say that, and there are no citations. And this is something I'd love to talk about more, but won't in the interest of time. It turns out, though, and I found this out completely accidentally, that there is a source for what sort of, at least for Marshall's recitations of the terms of the charters, and that was a book that John Marshall wrote. Did you guys know John Marshall had written a book? I discovered this at lunch one day when I pulled a book off the shelf in the Swarthmore College Library entitled The Life of Washington. And I thought, well, I'm a history graduate student, I should probably know something about George Washington. I sat down, opened it up, and it was really old. And it said The Life of George Washington, had one of those long, early 19th century titles, Life of George Washington, Commander-in-Chief of American Forces during the glorious War of the Revolution against the tyrannical reign of King George, it was one of those sorts of things, by John Marshall. And I thought, really? Who knew? And so I started reading it, and almost immediately realized the backstory on this is he wrote it as a favor for his colleague on the court, Bushrod Washington. By the way, Bushrod, a name that someone should revive someday. I didn't for my kids, but Bushrod was George's nephew. He had written this book while he was Chief Justice. He had no time to do it. Apologizes for that in the introduction. He has access to no primary materials, apologizes for that in the introduction, and has no self-control, evidently, too, because The Life of George Washington as Commander-in-Chief, he starts to write with the beginning of the Revolution, then thought, you can't really understand Washington's role in the Revolution without understanding Washington the man. So second iteration begins with Washington's birth, at which point apparently he thought, you can't really understand Washington the man unless you understand the world into which he was born, the world of colonial Virginia. So suddenly the next iteration begins with the landing at Jamestown, at which point, that may surprise you, he said, you can't really understand the Jamestown thing without understanding the history of European colonization. So The Life of George Washington, I don't think Washington appears in volume 1. It's 3 volumes, and volume 1 begins with Columbus. Now, to his credit, it's the first, I believe, comprehensive English language history of the colonization of the New World. It's also terrible. And because he just was pulling stuff off a shelf at home. He didn't have access to any of this stuff. And this is, it's sort of sad and funny. I will share the nicest review I found. I looked for book reviews. Said, the Chief Justice will add little to our literary reputation as a nation. That's a direct quotation. That was the nicest review, and he wouldn't have been surprised by it. But what becomes horrifying is this, you start reading it, and I realized almost immediately that I was reading the Johnson-McIntosh opinion. And I thought, of course, this history of America that justifies the holding, the creation of his version of the discovery doctrine, is cut and paste from his volume 1 of his biography of George Washington, which only made sense when I realized he only had a week to write it, and he would have had a copy of that book in his office. And of course, as I mentioned, it's a fiasco, The Life of Washington. So all of this was horrifying, this Johnson-McIntosh story, but it became even more horrifying when I realized what had happened with this discovery rule. And this is the Trail of Tears story. Marshall, I think, thought this was a one-off. For reasons I won't go into, but I think he thought nobody will ever hear of this. This is going to help Virginia in that dispute with Kentucky, and then it's kind of done. But this is the problem with inventing things and not inviting lawyers to make argument on either side to share potential consequences with you. It's not long at all before the governor of Georgia finds the Johnson-McIntosh opinion. And I like to think it was a young law student interning at the governor's office who said, "Your Honor, look." Because Georgia, as you know, had spent a fair amount of time obsessed with getting rid of you guys and the Creeks. And, it's really in Georgia's defense, but in 1802, when, as you all know, when Georgia ceded its western land claims, which is Alabama and Mississippi, whatever that meant, to the United States, part of the deal was the U.S. would enter into treaties with the Creeks and the Cherokees to get them to move west, and they hadn't acted on. The Creeks had agreed to move, but the Cherokees weren't going anywhere, and you know that story well. You've got a constitution, government, syllabary, written language, probably the most literate political community on the planet, and gold. So why would we leave? Things are pretty good, and you can see it's a fairly sizable chunk of northwestern Georgia. When the governor of Georgia discovered Johnson versus McIntosh, he realized immediately that this is our ticket out. And here's why. I mentioned that the discovery doctrine that Marshall had invented in Johnson versus McIntosh says that the discovering European sovereign owns the title to the land and the indigenous people own an occupancy right. Well, Georgia declared independence from England, and so Georgia has inherited, this is the argument, whatever that ownership of the underlying title is. Now, all of us at some point in our lives, I imagine, have lived in exactly that sort of a legal relationship where somebody else owns the title to the place you live, but you have an occupancy right. That's a landlord-tenant relationship, and that's exactly what the governor said to the legislature. We've just realized we are the Cherokees' landlord, and they are our tenants. Now, how do you get rid of tenants you don't like? Not that this would ever happen to any of you, but you change the lease terms. This is one way to get rid of tenants you don't like. And so that's what they did in December 1828, immediately after Andrew Jackson's elected president, when they think they can get away with it. The Georgia legislature passes a statute attaching Cherokee Nation to 4 Georgia counties, abolishing the Cherokee government, and imposing all sorts of newly crafted draconian Georgia state laws on people in Cherokee Nation, including a requirement that non-Indians in Cherokee Nation have the permission of the governor of Georgia to be there, a license and swear an oath, and this sort of thing, which is what's going to trip up Samuel Worcester and Eliza Butler. And then says to the Cherokees, you guys can stay as long as you want to, but these are the new lease terms. These are the new rules. Entirely based on their understanding of the Johnson versus McIntosh decision. Now, John Marshall gets that he has made a mess. There's a lengthy correspondence that I quote from in the book and I think talk about in the Richmond presentation. He's in communication with Senator Frelinghuysen from New Jersey and others. I think he was horrified that he had created this mess. And so he starts looking for a way to clean it up. The first crack will be Cherokee Nation versus Georgia, the lawsuit that's filed in 1831 when Georgia is threatening to impose its laws, starting to make movement in that direction. The Cherokee Nation, represented by William Wirt, who was a former attorney general, shows up in Washington. The state of Georgia is unrepresented because they don't believe the court, they're going to take the position the court doesn't have the power to interfere with the acts of a sovereign state vis-a-vis its Indians and this sort of thing. And the court splits. There's 6 justices who participate. Marshall can't get a majority in favor of a finding that the court has jurisdiction, and he himself isn't sure about it. The jurisdictional claim is under Article 3 of the Constitution. The court can hear this case, but only if, because it's a suit against a state, and the Cherokee Nation isn't a state or an individual, only if the Cherokee Nation is, for Article 3 purposes, a foreign state or foreign nation. 2 of the justices say, yeah, it's a foreign nation. It's a nation because it's got a government, and it's foreign because none of its citizens are U.S. citizens, which was true. 2 of the justices will say it's neither foreign nor a nation. And 2 of the justices, including Chief Justice Marshall, will say it's a nation, but it's not a foreign nation. And you've heard this before, it's a domestic dependent nation. Its relationship to the United States, and this is the source of this famous language, resembling that of a ward to his guardian. So this is the first appearance of that guardian-ward relationship language in U.S. Supreme Court case law. So this isn't the case, but Marshall concludes his opinion in Cherokee Nation versus Georgia, and this is a part that isn't cited in lots of places, with a message to Cherokee Nation, which is that this is a hugely important issue, this power of Georgia, the imposition of its laws, and in a proper case with proper parties, we'd be delighted to decide it. So Cherokee Nation's listening. Georgia celebrates a little prematurely. Cherokee Nation starts looking for the next case, and it doesn't take long because Georgia arrests Samuel Worcester and Elizur Butler for not having licenses or permission from Georgia to be in Cherokee Nation, and throws them into prison, sentences them to hard labor for a period of time. And they effectively ask the Supreme Court directly for habeas relief. They want to be released, and so Worcester versus Georgia, which should really be Worcester and Butler versus Georgia, we lose Elizur Butler. Jack and I have talked about this. It's troubling. And they get before the Supreme Court almost immediately. Again, Georgia's unrepresented because they're protesting this whole thing. Here's the courtroom, which you can visit today, where both of the cases I've mentioned and Worcester versus Georgia are decided. And here, by the way, so we'll be with him for a minute, is Samuel Worcester. The court gets this case and will decide for Cherokee Nation, and you all probably know that, and this is why this is like a big case. But the reason that gets cited from the opinion for the decision in favor of Cherokee Nation and against the power of Georgia to impose its own laws is, I think, the least important or the less important of 2 reasons. It's the reason that under the Supremacy Clause, treaties of the United States take precedence over state statutes, and Georgia and the U.S. and the Cherokee Nation have a treaty in which the United States recognizes Cherokee Nation as a separate sovereign with territorial interests and this sort of thing. And so under the Supremacy Clause, Georgia loses, Worcester wins, and Georgia loses. But as I say, I don't think that's the most important part. I think the most important part is before that. And it's a part that it's easy to miss, but it's what I want to sort of leave you with. The problem that Marshall had created, I believe, he's decided he has to fix. The Supremacy Clause rationale works if states are imposing their laws over treaty tribes. It doesn't help tribes without treaties. And I think he's decided that this business of holding that the title to indigenous lands vested in the discovering sovereign the fact that created a legal claim on the part of states to impose their laws as landlord, that's the real problem that has to be fixed. The challenge to Marshall is, and some of you may know this, I sat down, Wine helps with this, by the way, and read every Marshall court opinion in chronological order. He was on the court for 35 years. That's a lot of Marshall. But you'll learn a lot about people by reading everything they've written and published, as I believe I did. And one of the things that I learned was that Marshall never overruled himself. There is no opinion in which the Marshall Court says, we made a mistake and we're going to do it differently now. And I think that traces primarily to Marshall's concern to enhance the position of the Supreme Court within the federal system. It hadn't been anything before he became Chief Judge. It was like a glorified traffic court, and he turned it into, by claiming the power of judicial review in Marbury versus Madison, turned it into a major player in American political life. And so he didn't, if he came out and said, we were wrong in Johnson versus McIntosh, here's what the rules should have been, he would have placed the institutional authority of the Supreme Court in jeopardy. I believe he believed. So the challenge was, how do I do this without saying I made a mistake? And the answer, I'm going to read to you. And it's sort of stunning when you think about it. And it's hard to imagine anybody getting away with this today. But here's what he did. He decided, well, without referencing Johnson McIntosh at all, what if I just rewrite that section and craft an entirely new understanding of the legal consequences of European discovery, and then sort of cross my fingers that nobody calls me on it? Like, wait a minute, you said this and now you're saying that. And that's what he did. And I'll read this to you. And having read the earlier, it's been a few minutes, but sort of keep the disjunction in mind. The old one said the key part is title passes, and there's some diminishment of sovereignty. But listen to this. And right of alienation, the diminishment of sovereignty is that you can't sell to everybody you want to. Here's what he says in Worcester, 9 years later, 1832. The extraterritorial power of every legislature being limited in its action to its own citizens or subjects, the very passage of this act is an assertion of jurisdiction over the Cherokee Nation and of the rights and powers consequent thereto. So can they do this? And then he launches into discovery, which is George's rationale. The principle that discovery, et cetera, gave to the nation making the discovery as its inevitable consequence, the principle was, as its inevitable consequence, the sole right of acquiring the soil. I'm leaving out bits that aren't relevant. It was an exclusive principle which shut out the right of competition among those who had agreed to it. It regulated the right given by discovery among the European discoverers, but could not affect the rights of those already in possession. It gave the exclusive right to purchase, but did not found that right on a denial of the right of the possessor to sell. So we're already seeing a step back from the discovery doctrine. We've still got the restraint on alienation, but it's not based on limitations on the power of the tribes to sell. It must be, and he'll say this expressly in a minute, based on limitations on the power of Europeans to buy. So there is no reduction of tribal sovereignty. And I've made no mention of the vesting of title to the land yet. And as it happens, I won't. So the charter history, he's going to jump into next. Soon after Great Britain determined on planting colonies in America, the king granted charters to companies of his subjects who associated for the purpose of carrying the views of the crown into effect and of enriching themselves. And so now we're going to rewrite that history from Johnson McIntosh, skipping ahead. The soil, when they got there, was occupied by numerous and warlike nations, including you guys, equally willing and able to defend their possessions. The extravagant and absurd idea that the feeble settlements made upon the seacoast, or the companies under whom they were made, acquired legitimate power by them, the charters, to govern the people or occupy the lands from sea to sea did not enter the mind of any man. They were well understood to convey the title which, according to the common law of European sovereigns respecting America, they might rightfully convey, and no more. And here he's about to tell us exactly what Europeans got from discovery. Now, I want to say a word. I did a study in, all these people studied classical rhetoric, like John Marshall and stuff. And there's an interpretive rule. I'm going to mess the Latin up, but it's exclusio unus, incluso unus exclusio alteris or something, but it's a rule that when you say things like "and no more," you're putting a cap on this. So you're saying, whatever I say, that's it. Don't imagine that there's something more that I'm not saying. And here's what it is. Here's what discovery gets you. This was the exclusive right of purchasing such lands as the natives were willing to sell, period. Okay. He's just erased the vesting of fee title portion, which is to say Georgia does not own the title to indigenous lands. The United States does not own the title to indigenous lands. And if you want to go outside the U.S., and this is the rule, Australia does not own the title to Aboriginal lands. All of these indigenous peoples own their own lands and have the full unrestrained right to sell, although there may be limitations on who is allowed under the law of that European-derived state to buy. Now, just in case you missed it, Marshall said, the "and no more," and here's the rule. Let's hammer it home. Next sentence, the Crown could not be understood to grant what the Crown did not affect to claim, which is to say the vesting of title, although he doesn't have to say it, nor was it so understood. That's 4 times he has pounded this out. And I think this is Marshall's attempt to rewrite the discovery doctrine in such a solid, clear way that he doesn't have to say, and by the way, we understand we're overruling the Johnson versus McIntosh decision. And fingers crossed, from this point forward, these will be the new rules, and the other will be forgotten. Now, that's great. It's a hugely important moment, I think, in federal tribal relations. I think it laid a potential platform potentially for a much more expansive history of tribal rights in the U.S., full rights of sovereignty, no legitimate basis by states for claiming the power to impose any laws of their state laws on tribes in tribal territory, ownership by indigenous peoples of indigenous lands, immunizing them, in a sense, from that potential claim by states to impose their own laws. Why isn't that the rule today? And here's where this is, everything, what is it Faulkner said? The past isn't, it's a quote I quote all the time. I just blanked on it. Somebody, one of my students are here. What do I say? Never mind. No, not past is prelude. That's another good one. But it's the past. And it doesn't matter. That's okay. It doesn't matter. Yeah, it isn't even past. That's the second part. It isn't even past. And he's talking about the South after the Civil War, but I think in a sense it applies here. Because what happens after this it will sound familiar to you. This is 1832. Jackson, who's pushed through the Indian Removal Act, making lands available out west for tribes who don't want to be under state law to swap and move, says, supposedly, according to Horace Greeley, John Marshall's made his decision, now let him enforce it. But at the same time, knowing he's got to do something, sends his Secretary of War around to talk with the 5 nations and encourage them to go ahead and enter removal treaties, because clearly Worcester's bad law, and all of them but you guys and the Seminoles will. Seminoles go to war, as you know, in order to resist removal. And you guys, being Cherokees, start more political operations and internal opposition through the constitutional process to being forced to remove, with one group finally saying, we will sign a removal treaty. But the backdrop to all this is the Supreme Court. And they were aware of it, I think, more immediately than we are today, because people don't live forever. John Marshall will die in July 1835, his place taken by former Jackson Attorney General Roger Taney, who's more famously known or infamously for the Dred Scott opinion. Justice Johnson will die, who had been in the majority in Worcester. Justice Washington will die, and all of this is, it happens. Some of it started happening before Worcester came out, but it accelerates in the years after Worcester comes out. When Worcester was decided, John Marshall had 2 Supreme Court appointments. But as people start leaving the court in just the 3 or 4 years after the Worcester decision, Jackson is filling them like crazy. And then the court gets expanded by an addition of 2 seats. And then Jackson and his successor, Martin Van Buren, who was Jackson's second vice president, will just keep putting people on. By 1836, the majority of the court are Jackson appointees. And that will remain true for the next 8 years, which is the removal period. And everybody he puts on the court is a strong public advocate of Indian removal. And they immediately start erasing the Worcester decision in throwaway lines, in opinions that often have nothing to do with the consequences of European discovery. The first is an opinion written by Justice Henry Baldwin. As Marshall is dying, it comes out in the 1835 term as Marshall is dying, and it says, again gratuitously, it is with Florida lands under English law. By the way, when Europeans discovered the lands of the New World, they acquired ownership of the underlying title to Indian land. And then in 5 more opinions over the next 7 years through 1842, this Jackson majority will do the same thing again and again and again. 6 opinions between 1835 and 1842 hammer in the original Johnson versus McIntosh discovery rule. And that has become not only the law in the United States in consequence, but the law that we have exported to, as I mentioned earlier, Australia, New Zealand, Canada, and the rest of the former English colonial world. The consequences of the appointment power are something we're aware of, that courts can change when new presidents come in and get to appoint people more in line with their political views. This is not a new thing, but in the aftermath of the issuance of the Worcester opinion, it was enormously consequential for indigenous rights in the United States. And Cherokee Nation were the epicenter of this story. Now, the last thing I want to say has to do with John Marshall again. My wife, Lynn, who's back at the head of this table sitting next to Jack, and I had a marvelous afternoon yesterday through Jack's good graces. Lynn is a linguist, a 30-year language teacher with a strong interest in preservation of indigenous languages, and had wanted to see, as had I, the Cherokee Immersion School. And so we spent a couple hours out there on a fantastic tour. And one of the things that we learned was about the bell at the school, which is out front and is rung every time a native speaker passes. And this really struck me deeply. And I was thinking about it last night as I was thinking about this presentation. I thought, this isn't uniquely a Cherokee thing. The ringing of bells happened in the early American Republic too. When major figures would die, bells would be rung, and one of those major figures was John Marshall, who, as I mentioned, who did, I believe, at the end of the day, his best to preserve a truly robust respect for and legal recognition of Native rights, land rights and self-governance rights in the United States. He died in 1835, and one of the communities that mourned his passing was the city of Philadelphia. And they had a fantastic bell, which maybe many of you have seen, the Liberty Bell. And so they decided, let's pull that thing out and ring it to commemorate the passing of John Marshall. And when they did, they hadn't rung it in a long time, it cracked. And when you see the Liberty Bell now, those of you who see pictures of it or go to Philadelphia or take family there, see the bell and see the crack in the bell. I hope you will remember that story and of Marshall's passing, and that's when the crack appeared, but also maybe something of this story, that Marshall's passing and the filling of the court with Jackson appointees, I think, marked the passing of an opportunity for a richer political life for Native communities over the subsequent centuries, and a healthier federal-tribal relationship today. Thank you.